I will not contractually guarantee you anything. I will not tell you what specific things I will regard as your to be protected property. Nor will I tell you what I oblige myself to do if, according to your opinion, I do not fulfill my service. But in any case, I reserve the right to unilaterally determine the price that you must pay me for such undefined service. Now, any security provider would immediately disappear from the market if he made you this type of offer. But this is exactly the type of offer that states make to you. Each private, freely financed security producer must instead offer its prospective clients a contract. And these contracts must, in order to appear acceptable to the clients, contain clear descriptions as well of the property that they want to protect, that is, what they regard as yours. They must have clearly defined mutual services and obligations, and each party to a contract for the duration and until the fulfillment of the contract would be bound by the terms agreed to in the contract, and any change in the contract would only be possible if both parties to the contract agree to it. In contrast, you realize the state also changes the rules of the game as it goes along. It passes laws that make something that was yesterday legal tomorrow illegal, and vice versa. No such thing would, of course, be possible if you have a contractual relationship with anyone else. And specifically, in order to appear acceptable to security buyers, these contracts must contain provisions about what will be done in the case of a conflict or dispute between the protector and those people that are protected. That is, we all know conflicts like this can arise. I have a dispute with the police that is supposed to protect me, with the insurance agency that's supposed to insure me, with the arbitration agency that is supposed to arbitrate in conflicts. What do we do in such a case? Obviously, a contract would only be appearing acceptable to potential clients if there's a provision what will happen in those cases. And in those cases, there's only one solution. The solution is the insurer, the protecting agency, and the protected, the allegedly protected people, can only agree on something where they say, in that case, we go to some independent third-party arbitration. This is something very different from the current situation where whenever we go to appeal a decision, the next appeal court is also part of the same organization. The emphasis is here, the third party must be independent, otherwise clients and offerers of protection would not be able to agree on this. And these arbitrators, these independent arbitration agencies, are characterized again by the fact that they are also freely financed organizations. And if they don't do what insurers and insured expect of them, namely to come up with a solution that is considered to be a fair solution by all sides involved, they will not again be chosen as independent third party in the future. That is, in this market of independent third parties, only those people will be able to survive who have the capability of coming up with solutions that are deemed mutually beneficial, all around beneficial, and somebody who is considered to be a biased, a partial judge, a partial arbitrator, he will simply disappear from the market of arbitrators. Now, from this fundamental advantage of a private law society, a number of additional advantages follow. The fundamental advantage is there is a contractual relationship instead of a non-contractual vacuum, as it is currently the case. First off, competition among police, insurers, arbitrators, and so forth for paying clients would bring about a tendency toward a continuous fall in the price of protection per insured value, which would make protection, so to speak, increasingly more affordable, whereas under the current monopolistic conditions, the price of protection continuously rises and the quality of protection continuously falls. In addition, as I already indicated, protection and security are goods and services that compete with all sorts of other goods and services. If more services are allocated to protection, then less resources are available for buying a house or a car or going on vacation. Or if I offer more protection for one group, less protection can be offered for another group. As a tax-funded monopolist providing protection, all these decisions, how to allocate resources to this purpose or that purpose, are completely arbitrary. In distinct contrast, in a system of freely competing protection agencies, all arbitrariness of allocation, all over or under production of security would disappear. Protection would be accorded the relative importance that it has in the eyes of different consumers. Some people want more money to be spent on it, some people want to spend less money on it. And each and every one would, in a private law society, receive protection in accordance with its own desires and its own willingness to pay for the specific services. Now, the most important advantage of a private contract-based production of law and order, however, is of a qualitative nature. First, there is a fight against crime. The state is notoriously inefficient when it comes to fighting crime because the state agents entrusted with this task of protecting our life and property are paid out of taxes. That is, they are paid independent of their productivity. Why should anyone work if one is also paid for doing nothing at all? Why should I run after criminals, so to speak, if it is much nicer, for instance, to hand out parking tickets or to drink coffee at 7-Eleven stores? In fact, it can be expected that the state agents have even an interest in keeping crime rates moderately high because this way they can always justify that they need bigger budget allocations than they received in the previous year. And things are even worse. The state agents do not indemnify or compensate victims. They are supposed to protect us. But what if they fail? Do they then pay anything to those people that they were supposed to protect but didn't successfully protect? That is, for the state, victims of crime and the indemnification and compensation of victims play at best a very negligible role. The state does not compensate, indemnify victims of crime. To the contrary, the harmed victims are still further insulted by making them pay for the criminals that are arrested. It is the taxpayers then have to pay for the muesli and the TV and the table tennis entertainment that criminals that are housed in criminal facilities get instead of being compensated for the harm that was done to them. Now, the situation in a private law society is obviously entirely different. Security providers, and in particular insurers, will have to indemnify their clients in the case of actual damage. Otherwise, they would simply find no clients, and because of this, they must operate efficiently. They must be efficient in preventing crime, because if they are not efficient in preventing crime, then they have to pay. They must be efficient in finding goods that were stolen from you, because if they don't find them, then they have to pay. They have to buy you a new TV. States don't do anything like this. I always give the example, a friend had his VW stolen in Italy. He went to the Italian police, said my car was stolen. The police said, okay, we fill out a report. And then he asked, what will now happen? And the police said, no, yeah, we filed this report. We put it in a little booklet and that's it. Then he reported this case to his German insurance agency, and 3 days later the German insurance agents found the car for an obvious reason. If they find the car, they don't need to pay for a new car. The state doesn't pay a new car, they file things. And of course, private protection agencies would also have an incentive to find the perpetrators, because then they can compel the perpetrators to pay compensation to the victims, instead of them having to pay all of the compensation. In the other case, I explained that taxpayer, the victim must, as taxpayer, pay in addition for the incarceration of these people. In addition, a private, competitive, and contract-based security industry has a general peace-promoting effect. States are, as I have already indicated, by nature aggressive institutions, because they can cause and provoke conflicts and then decide the conflicts in their own favor. Or, to put it differently, a tax-funded monopolist of ultimate decision-making can externalize the cost of its own aggressive behavior onto hapless taxpayers, and because of that, they tend to engage in more risky and aggressive behavior than you would do if you would have to pay all the cost of engaging in aggressive behavior yourself. Moreover, insurance companies are by nature, so to speak, defensive organizations. On the one hand, because every act of aggression is costly. And if you engage in aggressive activities, you must charge higher premiums to your own clients.